We're back on the record with the people versus D'Angelo Jordan.
Thank you, Judge. May I proceed?
Absolutely.
Thank you. Looking at this case, the court should look at the totality of the circumstances to determine if probable cause that this arrest was a good arrest. Based on the probable cause, or based on the totality of the circumstances, this probable cause was established, and this was a good arrest for an OWI. Totality of the circumstances is the proper thing to look at to create probable cause because each OWI arrest is different. So that's why you need to look at the whole totality of the circumstances to see how probable cause was established and what the defendant was doing. Here we see bad driving. We see lots of different examples of bad driving. Excess speed, failure to maintain lane, delayed reaction time, almost causing a collision. Once the bad driving stops, then we see visible signs of intoxication, which is intoxication on the breath. Both officers testified to smelling odor of intoxicants from the defendant's breath. Both officers also testified that the defendant could not follow officer commands, which also indicates intoxication. All of these things together create probable cause looking at the totality of the circumstances. As defense stated, one of them alone may not determine probable cause and create probable cause in the situation. So that's why we have multiple coupled together with the bad driving, the failure to follow officer commands, and the odor and intoxicants all combined, looking at the totality of the circumstances, create probable cause. But further looking at MCL 764.15 says that an officer can arrest if they see the conduct and they don't even need probable cause, that they need to establish reasonable cause, which was clearly established from all the different signs, from the bad driving, from the odor of intoxicants, from the failure to follow officer commands. So probable cause and reasonable cause are clearly present here. Because of that, we asked the court to deny defendant's motion and rule that this was that probable cause was established. That probable cause was established through the totality of the circumstances. Thank you.
Just one moment, Judge. Well, first, Judge, this is the defense's motion. However, the burden is on the people to establish by preponderance of the evidence at a minimum that probable cause existed. Judge, one thing I think, well, a lot of things that we heard is Officer Honeycutt just clarified a few minutes ago that this bad driving didn't occur over the entire 1 mile they followed him. It was at the very end, just before she activated those lights. She was very clear in her testimony. She was the officer driving the scout car, probably the best vantage point. I'm not taking anything away from the other officer, Malloy, in the passenger seat. However, all this bad driving was at just before she hit the lights. It wasn't for a mile long. I think that really is important here. If we're following somebody and they're weaving across the lines and almost hitting cars, doing whatever for a mile, I think that gives you a lot more pause to think, hey, something's really wrong here. But for somebody who did 3 or 4 bad driving things in pretty much one action doesn't necessarily does not lead one to believe that they must be drunk. Now, we do not challenge the validity of the stop. They had a reasonable stop. They had enough cause to stop the vehicle. But it's what happened after that, Judge, is the problem. In this case, nothing happened beyond that, except smell of intoxicants, didn't cooperate with me. That was basically the whole reason for this arrest, that with the driving at the very last second. And these officers did not investigate fully. They didn't preserve all the evidence. I mean, there's body camera footage out there that they both testified that their own police department orders that evidence be destroyed after 90 days. Destroyed. Defense never even has an opportunity to look at that. I think that in and of itself goes to the court's decision, if there was evidence out there that the court is not entitled to to count that against the officers. But, I mean, even with the officer's testimony, it was merely failure to cooperate, I smell alcohol on him. I mean, that was the extent of it. Now, what I find very interesting, Judge, and I read the people's pre-hearing brief, we called it, and where is it? They quote from, the people actually say the defense hasn't provided any case law that says that field sobriety tests or PBT are required to establish probable cause. And I agree. There is no, at least from what I could find, no published case law that would state that. But the people go on then to almost burden shift, as if it's our responsibility to come forward with something to show that this is actually required. The people are right. Miss Rogers is right. It is a totality of circumstances, but it has to be substantial certainty. It cannot be a reasonable suspicion. The officer herself said the words, "That gave me suspicion when I arrested him." Now, I know she's not a lawyer, and I know it might be cutting hairs, but I think that really goes to the mindset here. They did have a suspicion. I don't take that from them. They just didn't have probable cause. Now, the one thing in the pre-hearing brief that the people cite is the unpublished decision. They're not citing published decisions, but the unpublished decision of People versus Robert Wright, unpublished, Court of Appeals, March 31st, 2016, case number 329023. And I found that a very interesting case when I started reading that, because they were using that to state that field sobriety tests, the PBT, those weren't needed. She was using the case law that stated it's a totality of circumstances, which is in there, Judge. But if we read that entire opinion that they want you to rely on, they want you to rely on this. The heart of the issue on appeal is whether the officers had reasonable cause to require a PBT. The heart of the issue wasn't, was there probable cause to arrest? The heart of the issue was, did they have reasonable cause to require PBT? And this decision says they do. Under those circumstances, they do. After they got to PBT, there was an arrest and subsequent conviction after that. But the actual case, unpublished, that the people cite does not lead to the proposition that somehow they are negated from providing meeting their burden for probable cause with the standard for probable cause itself for the arrest. Now, Judge, there's 98 clues. The officers testified. You heard it ad nauseum. That testimony 2 weeks ago took forever. But there's 98 total clues or indicators, according to our federal government, in the studies conducted from the National Highway Transportation Safety Authority. And in that, there's 98 clues. Now, of course, all of them can't exist because some of them conflict. But we'll say at most were 7. We said between 5 or 7. There were 7 clues they saw out of 98. That's not probably. That is a suspicion. That is not probably. If these officers had just moved to that field or identified a sidewalk, which was there, Judge, you saw a defense exhibit. There is a sidewalk there. Now, granted, I'm the one who went and reinvestigated this case, found the sidewalks. Too bad the officers couldn't have found that sidewalk while they were out there. I mean, it wasn't that hard to find, Judge. So I think that they could have done field sobriety tests. Had they done that, we probably wouldn't be here. If they just done the PBT, the statute's clear. 257.625A states officers can arrest based upon the result of a PBT, solely based upon that result. In this case, that didn't happen. I think the public policy in our statutes is that PBTs are taken for that reason. You heard the officer testify that when these clues can lead one to believe that somebody's intoxicated, but at the same time, they deal with a lot of people who don't comply. They deal with a lot of bad driving. Somebody crosses the lane. And that doesn't mean somebody's intoxicated. So while they do have reasonable suspicion, they don't meet their standard for probable cause, Judge. And because they don't meet their standard for probable cause to arrest, any evidence obtained after that should be suppressed. And I don't think that leaves the people with much of a case to even proceed to trial. So I think that would require dismissal either by the court or the people to know they prosecute. After the fact, I'm not trying to put the cart before the horse, but in this case, so much more could have been done. Everybody admits it. Everybody knows it. 7 out of 98 isn't probably. It's not substantial certainty. It's nowhere close to that. We're not even at the 20 mark. I mean, really, when we think about it, if I got a 7 out of 98 questions on a test on my exam, that's fail. That's not even probably I know what I'm doing. That's not probably I'm competent for that subject matter. That just means I fail because there are only 7 at most of the 98 clues. Even more important, Judge, the first officer, Officer Malloy, testified that the field sobriety test of horizontal gaze nystagmus, the HGN test, where you follow the fingers, have the subject follow your finger with their eyes. He admitted it can be done while they're in handcuffs. It can be done while they're on the side of the road. He just said, I don't do that. He said that a couple times in his testimony. I just don't do that. And I understand the officer may not do that or necessarily feel comfortable with that, but there's no officer safety issue. I myself am very concerned with officer safety issues. Obviously, this court knows I did 15 years out on these streets as a police officer myself prior to becoming a defense attorney. I can understand officer safety, but when officer safety is met, somebody's in the back of a car in handcuffs, we can take a PBT. We can actually have them follow our finger with their eyes. It can be done. And now, of course, what didn't come in was the stop before all the other stops, but each circumstance, as the officer Honeycutt testified to, each circumstance is different. And because they're each different, they determine how they move forward with their investigation based on the circumstances of the case at hand. However, Judge, that doesn't bind you or this court by any means to do that because you're not bound by what they determine. This court certainly isn't bound by what they believe is probable cause. It's an objective standard that we must look at. And I understand their concerns or their reasoning for it, but at the same time, that does not rise to the level of complying with the Fourth Amendment in this case. And because there is definitely no probable cause here, I believe the arrest and any results thereof should be suppressed under fruit of the poisonous tree. Just in closing, Judge, if the court wants the entire unpublished decision the people cite, I do have a copy of that. But again, even in an unpublished decision, the court's saying, yeah, you can require your PBT with that. You can require PBT. And also, Judge, I do need to say for the record, I learned something new today that the PBTs are not issued by the Detroit Police Department. I had no idea. But, and even so, maybe the officers were at a disadvantage. But they're part of the government, and the government has a burden when we want to arrest and imprison people or convict them of crimes. In this case, they simply just do not meet their burden for probable cause, even with the 7 clues they had, driving and otherwise. More should have been done, or could have been done. It wasn't. There is no probable cause. We would ask you to grant our motion to suppress the arrest and any of the fruits thereof. Thank you.
Yeah, thank you.
As defense has stated, I have provided case law to my brief, which the defense has not provided anything to establish why they're saying that you need to have field sobriety test or a PBT to create probable cause. If it is as easy as defense is saying that's a magic bullet, if you do field sobriety, you have probable cause. If you do PBT, you have probable cause. That's simply not how it works. And it doesn't work that way because of the nature of this offense. OWI intoxication looks different on every single person. So that's why there's 98 clues. That's why you base it on the totality of the circumstances. Because OWI's intoxication presents differently in every person. Field sobriety does not equal probable cause. Totality of the circumstances that support probable cause, that's when you get probable cause. And here we have that. So many different signs of bad driving. There's 3 different bad driving clues that they saw. Excess speed, failure to maintain lane, delayed reaction time. And I agree, bad driving by itself does not create probable cause for an OWI. That's not all we have. We also have odor of intoxicant, which also by itself does not create probable cause. But coupled with bad driving, and then also coupled with failure to follow commands of officers, all of that together creates the probable cause that is needed for a proper OWI arrest. And that was established without field sobriety tests being performed or PBT. And why you can look at probable cause and not have to have field sobriety tests is because each arrest is different. And here it was impossible for field sobriety to be done based on officer safety and civilian safety. As the officer testified, that you cannot conduct field sobriety tests in a dark field for a variety of reasons, for safety reasons, just for the practical aspect that the officers can't see what the defendant's doing. So they can have them do all these field sobriety tests, but if they can't see them, it doesn't matter. How would that create probable cause? Him doing something in a dark field that they can't see. Also, PBT by itself does not create probable cause. And the case that I've provided, People Be Right, it does talk about a PBT, but it talks about how probable cause is established in an OWI arrest. The court in this case does say the officers could have done more, but they did enough to create probable cause. And here, probable cause was established based on a variety of different things, based on the driving, based on the visible signs of intoxication, and the defendant's behavior. Because of all of that, people ask that the defendant's motion be denied and that the court find that this was a good arrest. Thank you.
Just for clarification purposes, statute 257.625A does state that a PBT result over .08 is probable cause to arrest in the statute. Just want to clarify. A lot.
In response to the clarification.
Yes, it may say that, or does say that, but it doesn't say it's the only way to get to probable cause. There's multiple ways, and we got here by totality of the circumstances.
All right. After hearing testimony, which included that Mr. Jordan on March 11th, 2020, around 4:15 a.m., was stopped after Officer Malloy and Honeycutt observed the defendant, Mr. Jordan, almost striking another vehicle. Officer Malloy's testimony. Not being able to stay within lanes, also perceived high rate of speed and slow reaction time. The officers pulled over Mr. Jordan. Once Mr. Jordan was pulled over and he stopped his vehicle, Officer Honeycutt was the driving officer and the one who walked to Mr. Jordan's window, and she stated that immediately she smelled alcohol on his breath, that he could not follow basic commands after being told to put his hand on the wheel. After the defendant stated that he had CPL, and then she observed Mr. Jordan reaching for items, that he had slow reaction time, and for officer safety, she then asked Mr. Jordan to step out of the vehicle, and as well because of suspicion of OWI. She also stated that once Mr. Jordan stepped out of the vehicle, the smell of alcohol was even more prevalent. Now, with GPD, now be charged to the officers in this case here. They, in my opinion, are ill-equipped in many ways, the way in which they put their officers on the street when it comes to this type of case. And it was not known to me that officers have to pay for their own PPT equipment. They don't receive training automatically for that. These officers are on patrol, which means that they will typically have drunk driving cases. And the policy to discard evidence after 90 days, to me, is unacceptable. I've had this issue with other cases, and I do believe the officers could have done more. They could not have done PBT testing because they're not trained in it, not certified, or they have the equipment, they fight. Field sobriety test, I'm not sure that I would feel that it would be safe based on the circumstances, being a busy road, as well as being dark at night. I do think, as Attorney Whitey did state, inside of the vehicle, there's been a test on the basic test with the horizontal, to just move fingers back and forth to see whether or not there are any indicators of intoxication. However, there is nothing that states that I can gain from both arguments that says it is required that officers conduct a PBT for some type of field sobriety test before arresting someone for drunk driving, in this case, operating while intoxicated. As Ms. Rogers stated over and over, totality of the circumstances is very important in this case. And although 7 out of 98 factors sounds like a bad score, there's no set number for circumstances in this case, the type of circumstances, to say that, oh, he met the threshold, he's at 10. I believe with the swerving, not being able to stay in the same lane, the delayed reaction, the fidgeting of hands and vehicles, not being able to follow commands, the smell of alcohol, I believe all those in the totality of circumstances was enough or probable cause to arrest Mr. Jordan for operating while intoxicated. So based off of what I heard in the last 2 hearings, I am going to deny defense counsel's motion.
Thank you, Judge. I think at this point then we would need to just schedule another pre-trial. I'd like to speak to my client about options or potential resolution, or if we're going to be going to a trial.
Sure. Do you have a date in mind? For a pre-trial?
Well, thank you, Judge. And also just for the record, this is charged as a high VAC. That's the highest OWI offense, and I can amend down to an OWI. If it's just going to be a pre-trial.
Yeah, just pre-trial too.
I know whenever. That's kind of the when I do it beforehand.
Judge, both myself and Ms. Rogers are before this court for another evidentiary hearing on March 30th at 10 a.m. I don't know if we could handle this matter as well.
That's fine.
Okay.
Would it be 9:45 or just 10 o'clock?
Yeah, we're scheduled for 10 for the hearing, so we'll just, 9:45 is good. I'll be here though, Judge, so.
Just so I'm clear, the pre-trial, either a plea will be taken or we're picking a trial date?
That's my guess.
Okay.
That would be my, yeah.
Okay.
No more motion with you?
Well, Judge, after, there'll be a lot more motions now that I got that testimony about certain other things.
Yeah.
That just opened the door to a lot.
I had no idea.
But no, on this case, Judge, I don't see any other, Judge, actually, if we do go to trial, I just want to place on the record so nobody's caught off guard. If we do go to trial, especially jury trial, I will seek a negative inference instruction regarding the lack of preserving the evidence of the body camera. If we're going to trial, and that'd be a motion to eliminate one of the quick, short ones, not anything drawn out like this.
Okay. All right, so March 30th.
Right, thank you. Mr. Jordan, I'm going to give you a call, okay? All right, hang